Thank you for listening to this episode of The American Idea. If you enjoyed this episode, remember to subscribe at Apple Podcast, Spotify, or wherever you get your podcasts, and leave a 5-star review. If you want to learn more or get involved in Ashbrook's vital work, visit our website, ashbrook.org. Well, I want to welcome everyone to this special episode of The American Idea. The Supreme Court is wrapping up its term here, and they've handed down some important decisions throughout the term, including here in the last few weeks and days. So we wanted to turn to our old friend and Supreme Court expert, Professor Josh Dunn, for his thoughts on this term. Many of you know Professor Dunn. He teaches politics at the University of Colorado. He is a widely published author on the Supreme Court and on the federal judiciary, and also has edited this wonderful collection called the Judiciary Core Documents Volume for Ashbrook. Has done an absolutely wonderful job in this. I use this in my classes when I teach the Supreme Court. I just shamelessly steal everything I have and know from Josh. So, Josh, thanks for taking the time today to join us.
It's great to be with you, Jeff.
All right, the court's term, very timely. If you had to characterize the 22-23 term, give us a word or a phrase for it. How do you think about it?
Wow. So very, very significant term, probably not as significant as last year's term. But when you have three cases, just like the three that we've had the past 2 days, this is going to go down as a major year in Supreme Court history. So yeah, I would, very significant, to close to being blockbuster status for the Supreme Court.
All right, a major year. I like that phrase. It's really helpful to think about. A little less than blockbuster, but still more than your ordinary year, right?
Yes. Yeah. I mean, there are cases here that we're going to be reading. People read 50 years from now. That's how you can look at it. Some real landmark decisions.
So take us through, in your opinion, and start with one of those decisions, either recently or from the earlier parts of this term.
So yesterday's decision on affirmative action, I think, is probably going to be the most significant decision of this term, for legal reasons and political reasons, just because of all of the political conflict surrounding affirmative action. So that's Students for Fair Admissions versus Harvard. Of course, there's a North Carolina case, but they combined them into one decision. So I think that decision, which really does, I think, eliminate the possibility of using race in college admissions, and then also is going to have more far-reaching effects on hiring, I think, and even beyond in K-12 education. There's going to be many years of universities grappling with this. Obviously, some have already indicated they want to try to find ways to work around it. So that means there's going to be more litigation. But I think that's going to be the most significant case of this term.
Can you talk a little bit about what you think some of those the reaction to this, the effect of this? Because you suggest one reaction from universities might be, let's figure out a way to kind of get around that. And even I saw today
Right.
that Harvard University put out a statement suggesting how they might try and get around that by saying, okay, we won't use race, but we'll ask essay questions to let students talk about obstacles they've overcome, including the obstacle of race.
Right. Yes. So I think the difficulty for colleges will be that if they announce that they're coming up with a different admission system to essentially arrive at the same result as a way of getting around the Supreme Court's decision, that's going to place them in legal jeopardy. I mean, Chief Justice Roberts warned them in his decision and said, look, there aren't going to be, if you just try to adopt some other way of having students write essays as a way of getting around the requirements of this decision, you're going to be in trouble. And he was responding to the dissent by Sotomayor, who essentially said, well, here's how you can get around it. And then he said, look, it's generally not best to rely on dissenting opinions uh, for figuring out
Interesting.
the requirements of the law. So I think that the majority in the decision is going to be looking for universities trying to evade the requirements of the decision. So if I were a university, I would tell people to be quiet. Be careful what you say. If your goal is to try to come up with what looks like a racially neutral admissions process, but one that's going to lead to the same kinds of results, you better not have that in an email anywhere. I would say the discovery process will be interesting in some of these cases. So that's one thing. You will have universities try to do that. There might be some, and there's a big question, a debate going on right now about, well, could socioeconomic status still be used? And I think the same. My reading is that a kind of tightly constructed admissions program that does provide advantages to students based on socioeconomic status could survive. But if you have a university that implements that kind of admissions program and they end up again with the same results that they had before, that's immediately going to make the justices suspicious. And I think some of those cases will get to the court.
To me, that's very interesting because it seems like there's not just a new decision being handed down, but as you're suggesting, almost a new attitude by the court. Because previously, I'm thinking of the Grutter case from 2003, the court seemed much more, we'll take the word of universities. We're not going to police this too carefully. We'll let them develop things because that they really know better than us, or at least we understand their reasoning. We're not going to police it so vigilantly. And that right. Of course, it's not just the court speaking for itself, but also signaling that to lower courts. Here, you're suggesting the court is adopting a much more vigilant, proactive attitude.
Yes, I think the request, and the court even put it this way in the decision. Chief Justice Roberts put it this way: the colleges and universities are telling us, saying, "Trust us," and the response of the court is saying, "We don't trust you anymore." And I think that comes from some of the attitude of both Harvard and North Carolina to some of the justices questioning, particularly at oral argument. I actually think their attorneys and the universities themselves made a significant blunder in their strategy, because it was clear that the justices did not like the idea that both Harvard and UNC didn't have any date in mind when they might be able to eliminate race-conscious admissions policies. And then they look back to the Grutter decision and they say, well, basically, we kind of said, you got 25 years to figure it out. There's a famous quote from Justice O'Connor saying, well, in 25 years, we hope that this won't be necessary anymore. And then at oral argument, and it came up in the lower courts as well, but at oral argument, I think there were two of the justices who tried to almost throw them a lifeline and say, all right, could you give us some kind of time frame when you might be able to wrap this up? Indicating that if they had given them a date, maybe they would have let them wind it up on their own time. And then if you're the universities, I would think, well, it's clear the way the justices were leaning, it would be better to give them a date that maybe it's after 2028 when the 25 years would be up, but maybe you say, well, 2035 or something like that. Hey, a lot can happen in the intervening years. You can have changes in the court's composition, but they wouldn't even do that. They didn't even give them some kind of rough time frame. They basically said, we don't know when it will end. We don't know when we can actually meet our expectations for what a diverse student body would require. And the justices said, well, that just means that we don't trust you anymore. We told you to work towards this. You haven't worked toward it.
I see. So you also said that this might move beyond higher education into K-12 education and also into hiring more broadly across the country. And one of the things that's noteworthy is a lot of deference had been given to the use of race in higher education because of the importance of a diverse, racially diverse student body, on the assumption that a racially diverse student body means a viewpoint diverse student body.
Right.
So more deference was in a way shown to higher education than to K-12 education or to employers. If it's been struck down now in higher education, do you expect the same things to be struck down in K-12 and in other employers?
Yeah, so in K through 12, the court had actually refused to say that race was or diversity was a compelling government interest that could justify the use of race or racial classifications. And that came from this Parents Involved versus Seattle case. And the problem with that case was that there were 4 justices who said race could never be a compelling diversity could never be a compelling government interest justifying the use of race. But then you had this odd, really self-contradictory, controlling, concurring opinion by Justice Kennedy, who said what was going on in Seattle, and there was another case from Louisville. He said that what they were doing was unconstitutional, but he didn't completely close the door to some considerations of race. It wasn't clear what that would look like, though, because again, his opinion was fairly inscrutable. Now, fast forward to today, where you see this becoming an issue is that some school districts, particularly with magnet schools, some really elite magnet schools, ones that are known for their academic rigor, have changed their admission standards in order to generate more racial diversity or a student body that looks more like the community that they're in. And most famously, this has happened in Fairfax, Virginia, with Thomas Jefferson High School, which is rated as one of the best high schools in America consistently. And 2-3 years ago, they got rid of their admissions program, which is purely academic merit-based. You basically just took this really demanding test to see if you could get in. And Asian students were consistently getting 65 to 75% of the seats at Thomas Jefferson. And the school district basically said they didn't like that because they wanted something that was more racially diverse, adopted what on the surface appears like a neutral admission system. But if you go back and look at the reasons that were given by the school district, it raises this question about whether or not they were adopting an allegedly facially neutral system in order to discriminate on the basis of race. That is to reduce the percentage of Asian students and increase the percentages of other students. I don't think that school districts can get away with that now. That's just not going to. I mean, if you're a school district now, those kinds of, if you change your admissions program, a policy, and there's any indication that you were doing it for those reasons, it's going to be struck down. Fairfax they were initially struck down by the federal district court. Then the federal appellate court overturned the district court, upholding the new admissions policy. I don't see that surviving, though. I think there are some justices who have indicated that they want to take on the case. So I think that's where you're particularly going to see it.
Mm-hmm. So this is a major decision, as you say. People will be reading this case, could be for the next 50 years, particularly if it plays out as you're suggesting. And it really does have the effect of removing race consciousness from much of American law and especially in education. What other decisions of the court this term would you characterize as major?
So the 2 that were just announced today, and I've only been able to briefly go through them, but they were major cases. This 303 Creative versus Alenus. It's about a woman who had a wedding website design company and wanted to be able to refuse services to gay couples who wanted to hire her to create wedding websites for them. And the Supreme Court agreed with the owner of the website design company. Essentially, their argument was this is speech. What she's engaging in is speech. And there's a long line of cases. And one of the most bedrock free speech cases in American history is West Virginia versus Barnett. From 1943, the famous flag salute case, which I'm certain all the teachers have heard of. But the basic principle there is the government cannot compel speech. They can't compel speech, and the majority in this case, again, it was a 6-3 majority with the conservative bloc, and then the 3 members of the liberal bloc dissenting. The majority said this was the government compelling her to engage in speech that she disagreed with. So that's going to be significant. So
I can clarify that, sorry, Josh, for our listeners. So the Supreme Court had previously held free speech means that government can't stop you from saying certain things, but it also means government can't force you to say certain
Right,
things.
right. Yes, government cannot compel you to say something that you disagree with, like saluting the flag, which they held was a form of speech. And there's this famous line uh, from West Virginia versus Barnett, which says there's no fixed star in our constellation greater than the idea that no official high or low can determine what's orthodox and compel individuals to state their belief in that. So yeah, it's been, and if you go look at that decision, that's really the first case the Supreme Court cites to base its ruling on.
So is this a continuation for our listeners that might want to know, is this case a kind of continuation of the Masterpiece cake decision? Is it, they avoided the decision in this case, they avoided the core issue and just, I think, said that the baker had been sort of subject to hostile targeting by the Colorado Commission that was overseeing this. Here we don't have evidence of that hostile targeting. We just have them taking, I think, this case up on the merits of the question.
Right, exactly. She was saying that this was going to happen to her under the law, and so she had not been punished under the law yet. So this does clean up some of the things from the Masterpiece Cake Shop case, although it's a little bit different because one of the issues in Masterpiece Cake Shop is their protection under the free exercise clause, and the court didn't fully address that. All they said, as you indicated, it was that the behavior of the Colorado Civil Rights Commission was unconstitutional because it betrayed animus towards religion and not neutrality towards religion. But it didn't reach the question of whether or not there was protection under the free exercise clause more broadly. That is, that on grounds of conscience, you could refuse to serve customers who, and the issue in Masterpiece Cake Shop was again, he was asked to create a cake for a gay wedding. So the issue in today's decision was purely free speech. Purely free speech. I don't think there was any. The free exercise clause might have been mentioned. I'd have to go back and look again, but it was really grounded in freedom of speech, and it just so it didn't get to this question of free exercise. So there could in the future actually be cases that maybe aren't controlled by this, but are related, that would raise free exercise questions.
I'm thinking now of the dissent, which I happen to just take a look at briefly today. And one of the dissenters asked the question, all right, if this is a matter of compelled speech because website design is artistic expression, that's part of freedom of speech, long held, and the government can't compel her to do artistic expression in favor of this point of view. The dissent asks, and I'm wondering if you have some thoughts on this. Okay, what's the line? So for example, a gay couple comes into a restaurant. The restaurant owner says, I can't have that in my restaurant. It's opposed to my religious opinions, for example, or my beliefs. Well, what's the line? Is there any indication about that in this case, or will that have to be settled by future courts and maybe even the Supreme Court?
Yeah, there are going to be cases that will arise under that. As it stands right now, I can't see how the restaurant owner wins in that case, because particularly if you're providing a general service and it's not specialized. And so, of course, in Masterpiece Cake Shop, that was the issue for the owner of the store, was that he said, I will sell you any kind of cake that I've made. I'm not going to make a special cake and then write things on the cake celebrating the ceremony. And I think there was, maybe something similar going on with his 303 Creative case, because it was so inherently tied. The nature of her work was inherently tied to expression. Even the state of Colorado admitted that she was engaging in expressive activity, which was a pretty significant admission if you go and read Gorsuch's opinion. That he emphasized that they actually admitted that this was expressive. So the case of the restaurant, I think it's going to be difficult to say this is expressive conduct that you're engaging in. So I don't see it, but I think there are going to be more cases where people are going to say, look, what I do has an expressive component to it. And therefore I should be exempt from these requirements. So yeah, there's going to be more litigation.
More broadly, religious liberty cases. The last time you and I talked, you said that religious liberty, particularly free exercise of religion, has been on a roll lately and has been winning at the Supreme Court. Are there any cases or issues in front of the court this past term that suggests that's true or not true?
Now, the case involving the postal delivery worker, and I'll think of the citation in a second here, but this was just handed down recently as well, where they were he claimed that compelling him to deliver mail on the Sabbath was in violation of his rights, and the Supreme Court agreed with him there. And I'm trying to think about others. There probably are, but that's the one that immediately jumps to mind. Yeah.
So, Josh, you're an observer of the Supreme Court. Were you surprised by that postal worker decision or not?
No, I wasn't surprised. Again, the court has just been consistently moving in this direction of increasing protection under religion, both under the free exercise clause, and I think they'll do so statutorily as well. So I wasn't surprised, and I'd have to go back, and I think he actually, I'm trying to remember what the breakdown is for the court. That one might have been unanimous or close to unanimous. So that was that was an interesting one, which didn't surprise me too much.
So what about other, again, you characterize this as a major term. Are there other, besides the affirmative action case, the website design case, the free speech case, are there other decisions that you would regard as pretty major, whether those are in constitutional rights or in constitutional powers?
Yeah, so again, today's decision in Biden versus Nebraska involving President Biden's student loan forgiveness program. That and again, they ruled against President Biden, again, a 6-3 split on the court. And I think there are some broader implications to this beyond just that this is a highly salient political issue and a kind of a centerpiece of the president's domestic policy agenda, but do relate to longer trends in the court's evaluation of institutional powers. Because what they argued, what the majority argued was that this was not a minor modification of the statute, the HEROES Act, that President Biden was engaging in. It was a kind of a wholesale revision of it, and they said that, look, you just aren't allowed to do that under the HEROES Act. You can make minor modifications. Congress would never have expected the president to be able to do what he did without going back to Congress for support for it, as members of Congress had actually said. But it also, there was an interesting concurring opinion by Justice Barrett in that case, where she talked about the major questions doctrine and whether or not that's textually justified. And the court did not decide this case under what's known as the major questions doctrine. But the idea behind the major questions doctrine is that if some kind of regulatory activity by the executive branch involves a major question, then the authority given to the agency must be really clear, right? Congress must have clearly intended to give the agency the authority to do what it wants to do. Lane, last term, the big case was the West Virginia versus EPA, and Justice Barrett's concurring opinion provides a really full-throated defense of the justification for the major questions doctrine, which I also think indicates the appetite on the part of some of the conservative justices to be more aggressive and restricting the use of executive power, particularly as it comes to administrative agencies.
So that means that, as you say, the court ruling in this case that Congress makes the law, the president enforces the law. If he's going to enforce the law, he can't change the law so much as to essentially make it a different law. That would be making
Yes.
law.
Yes. I think that's at the core of the Supreme Court's the majority decision, again written by Chief Justice Roberts. If I again just read it maybe an hour ago. But,
Right.
yeah.
But do you think this, again, I guess the same question I had for religious liberty I have here. Do you think, and you indicated that perhaps among some of the members of the court, is there an appetite on the court to reconsider some longstanding cases that have bolstered what some people call the administrative state, which is the sort of making of a lot of rules by the federal bureaucracy that have the force of law and have the reality of law. And people have argued that power needs to be taken back by Congress, and it should be Congress passing those laws and not delegating that authority to the federal bureaucracy. Do you think there's a broader appetite on the court to
absolutely, very much so. And you know, there's some who've been itching to do this before they got on the Supreme Court. Justice Gorsuch, for instance, has raised questions about what's known as the Chevron doctrine. And the Chevron doctrine is essentially a doctrine that gives wide latitude to administrative agencies in their interpretations of their authority that's given to them by Congress. And so basically it's a policy of deference towards administrative agencies. And obviously there's just Justice Gorsuch, who I mentioned, but I think there are a few others. So I think the combination between trying to chip away at the Chevron doctrine and this major questions doctrine, the two of those combined mean that there's just going to be a lot more activity by the Supreme Court trying to rein in its view, the executive branch and the administrative state and administrative agencies.
Are there other examples this term where you can think of, again, major decisions where the court has been particularly active or aggressive or really willing to take on the law?
There probably are, but they're escaping me at the moment.
How about any questions? You know, we've been talking a lot about domestic issues. How about any Supreme Court decisions this term that you think are important for our listeners to know about matters of national security, foreign affairs, the border, anything like that?
Yeah, again, this is what there must be, but right now I'm just, I've been thinking about these past 2 days so much. I'm having trouble remembering what's happening, because they tend to say that, but if they're you must have some in mind. Maybe you can jog my memory, but
I was thinking of the one case, and maybe it doesn't rise to the level of major, but the case brought by Texas, and the question of who has control of sort of foreign policy around the borders.
Right. Yeah. So, so that's significant. There's some, that's where some of the conservative splits, so that's one where, and it raises questions of federalism, of course, because states that are on the border have been, particularly Texas and Arizona, have been arguing that more needs to be done. If more is not done, that they need to be empowered to do more, and that so that. But of course, as I understand it, when
you say the conservative split, as I understand it, it seems right based on the vote. And I understand it, they're really splitting over: do states still have authorities to sort of police borders, like can the governor send the National Guard, or do they have to back off because some areas under our Constitution really are reserved just to the federal government? And even if the federal government's not doing what you think it should be doing, it's still left up to them.
Yeah, I think that's the implication of the decision. Yeah, that's states, it doesn't matter how, states can believe that the federal government is failing to do its job as much as they want. But I think the implication of the decision is this is a federal issue, and so the states are not allowed to intervene.
So would you characterize, it's interesting listening to these decisions, that I guess that's not really a matter of deference to either side. It's ruling between a state and the federal government. But would you characterize this court? I'm just thinking of President Biden's remark. Someone at a press conference asked him, what do you think about these decisions? He said, this is not a normal court, were his words. What do you think of that assessment of the Supreme Court? And by that, I think he meant, at least in part, they are very, very active, and some people might even say activist.
Yeah, so that's actually what the dissenters argued as well in the Biden versus Nebraska case, which is interesting because if you look at the dissenters, I mean, for a long time, justices on the left actually engage in a kind of full-throated defense of activism. That is, the court needs to play a robust and aggressive role in our political system. And I think it was actually the first line of the dissents in Biden versus Nebraska calls out the majority for going beyond the proper boundaries of for the Supreme Court under the Constitution. So the question, though, is whether or not these terms activism versus restraint actually have any real meaning, though. The fact that you can see both sides kind of switching on it makes you question whether or not there's any substance to those terms. I've long been skeptical of the claim that they actually mean anything other than because what happened is activism kind of became a dirty word. And so what happened was activism is all the stuff I don't like, and restraint is all the stuff that I do. So it's really a signal of what you like. Now, I do think that what you can say is that in some ways it's abnormal because politically, for a long time, the court did end up giving and supporting positions that were really central to the left in the United States. Obviously, Roe versus Wade, decisions on sexual autonomy, Lawrence versus Texas, and Obergefell. And so they were. I think people got used to that. That the court always kind of moves. If it's going to move, particularly in these hot button social areas, it's going to move in one. It's going to move in one particular direction, and it's not doing that anymore. So in that sense, it's different than what's come before. So you can see why President Biden used that term.
So would you say that the course of cases you were talking about, the affirmative action case, the website design case, and some others here, you mentioned that a lot of the votes were 6-3, six conservatives, 3 liberals. That's the way, of course, the media often, and certainly though that's true, they voted that way. The media often portrays the court as divided between political conservatives and political liberals. Do you think this term justifies that characterization, or is it more complicated than that?
It's more complicated because in most cases you don't. I don't think you see that breakdown. You do tend to see it though in these more higher profile cases that raise often social issues or really divisive political issues. I'll give you another case though. The Moore versus Harper case, where which will also go down as significant because Republicans had argued for what's known as the independent state legislature doctrine. And their argument was that under the Constitution, state legislatures were given sole control over their the drawing of district lines for both Congress and state legislatures, and the basically saying that state courts could not intervene, shouldn't be able to intervene. They would have no voice. Now, federal courts, of course, have long intervened in redistricting cases, but the idea was they couldn't because North Carolina Supreme Court had declared that one redistricting scheme by the state legislature was unlawful, and the Supreme Court rejected that. But I think it was 6-3, and I think it was just Chief Justice Roberts and Justice Barrett, I believe, or maybe Kavanaugh, that joined the 3 in the members of the liberal bloc in ruling against North Carolina in that case. So you do sometimes see breakdowns like that, but there's an element of truth that, I mean, you have a pretty good idea where at least 3 justices will wind up on these higher profile cases on the left, and 4 to 5 justices on the right. You got a pretty good idea. There can be some uncertainty, though. Chief Justice Roberts can sometimes vote against expectations. Justice Gorsuch can vote against conservative expectations. After all, he was the one who said that sexual orientation and gender identity were protected under the Civil Rights Act, which makes today's decision interesting in the 303 creative case, because he wrote the majority opinion there, and so the person who wrote the opinion essentially declaring those categories as protected categories also authored this. So he can vote against expectations. Kavanaugh too as well. But in general, there's an element of truth to it.
And what about the newest justice, Justice Jackson? She replaced Justice Breyer, I think.
Yes.
Has that what impact or effect, if any, has she had on the court?
I don't think much, simply because she votes the same way Justice Breyer would have voted on these cases. It maybe moves it some to the left, because Justice Breyer could sometimes vote against expectations. Not often, but sometimes. I don't see her doing that though. But I can't think of any cases where I would have said, oh, well, Justice Breyer might have voted differently than Justice Jackson so far.
Is there a particularly, for our listeners who are not the kind of dedicated Supreme Court watcher that you are, was there a particular case this year that sort of flew under the radar that was really important that just didn't get a lot of press, or a case that we ought to be thinking about or considering that, again, didn't get wide publicity, that was important for this term that we just might not really know much about?
Yeah, I'm certain there will be one. And it seems like there are always cases like this, but sometimes it takes time to identify them.
Oh yeah,
because you don't know how they're going to be litigated, what the principle, how the principle is going to play out in lower courts. So I can't think of one.
Was there a case?
But I'm certain there's. Yeah.
I was just going to wonder if. Well, okay. So was there a case or a decision or an outcome that surprised you this term? Or the court voting along the lines of what observers like you kind of thought it would be voting?
Yeah, I'm not terribly surprised by any of the outcomes that I've seen so far. Again, particularly in these ones that we've been paying the most attention to. And if you listen to oral argument too, predicting based on oral argument can be dangerous. But it's one of the best guides we have, and so you can kind of get a sense of where the justices want to go from oral argument, and so particularly in these cases, I think I listened to the big three from today. I listened to the oral argument, and I'm not terribly surprised based on the oral argument. The one where I thought, well, maybe there could have been a different outcome would have been the Biden versus Nebraska, but on standing grounds. But I wasn't terrible. I didn't think that was going to happen, but I thought that if there were going to be a different outcome, you might have seen a couple of the conservative justices say that none of the plaintiffs actually had standing, and therefore they couldn't decide the issue. But obviously they did. They said Missouri has standing, and so and you only have to have one, as long as one of the plaintiffs in any of the cases has standing, and you can decide the whole issue.
So what do you think is next for this court? Are we going to see in the next term? Are there other big cases coming down the track that the court has already taken or bubbling up? And do you think that kind of 6-day block will persist into next term?
Yeah, I do. I think it's going to persist. And I haven't seen any really big cases. There might have been some that have been granted certiorari, and there are always some, and you never know what's going to arise too. After all, the student loan forgiveness, that kind of came up pretty quickly. So you don't know exactly what's going to happen. I do think there's a very strong likelihood that this case about Thomas Jefferson High School in Fairfax gets to the court fairly soon, likely next term. And that will be a big one. I do expect to see more cases involving administrative power, and some of those aren't going to raise the most that I mean, the issues won't necessarily be the most exciting sounding issues, but will have significant implications for the power of the administrative state. So I'd expect to see a few cases like that keep getting in the court. Guns, I wouldn't be surprised to see another big Second Amendment case as the court has to continue working out what the doctrine on the Second Amendment is going to look like in practice. So yeah.
Well, we will have to have you back at the beginning of the court's term this coming fall to preview what's likely ahead for the court. Josh Dunn, thank you again for taking the time to join us today. Really appreciate your insights into, as you said, what was a major term for the Supreme Court.
All right. Thanks for having me.
Thank you for listening to this episode of The American Idea. If you enjoyed this episode, remember to subscribe at Apple Podcast, Spotify, or wherever you get your podcasts, and leave a 5-star review. If you want to learn more or get involved in Ashbrook's vital work, visit our website, ashbrook.org.